As I understand it, did you take that test, Mr. Hankins, already? Okay. Which one?
Right. This is cause number TR 2121. State of Texas versus Quincy Lamar Hankins. Mr. Head, Ms. Curry, the court is not making a record today with the official court reporter because this was not a scheduled hearing, and there is no court reporter available for this hearing. So this will not be. It will be recorded by the court's internal recording system. Can be available for transcription at a later date, but there is not a court reporter present today. So is there any objection, and is there a waiver to moving forward without a court reporter for this hearing?
No objection, mistake.
No objection.
Okay, all right. Okay, so what do we got?
So, Judge, I know that we're set for trial on Monday, and this is a matter that I think the court would rather take up today than at a time after jurors have already assembled and we're waiting for us to take care of business. I'm in a difficult position, Your Honor, and as is Ms. Heisel and Mr. Woodwhite, who are prepared to try this case next week. And we want to make sure that we are complying with our ethical and statutory obligation to seek justice. We spent a good bit of time this morning talking about that, and we're here today anticipating that we may in fact file a motion to dismiss this afternoon. That is our plan. But I want the record to be clear as to exactly why we are doing that and exactly why we are not doing that. So I'd just like to, before we just blindly follow a motion, I'd just like to make some statements for the record, if that's with the court's permission. This case was indicted sometime in 2019. I believe we received it was indicted in 2020. And we had previously received a letter of rep from Mr. Head in 2019. And then the case was indicted. Shortly after it was indicted, in July of 2020, Ms. Heisel reviewed the case for grand jury, prepared the indictment, and also prepared our standard pretrial letter that sets forth how discovery works, motions, that kind of stuff. At the end of the standard pretrial letter, we make a plea offer, and the template for the letter, standard language, says that plea offer expires within 60 days. Mr. Head and Mr. Weiner received that letter because Mr. Weiner communicated back to Ms. Heisel on August the 10th of 2020, indicating that he had received the letter and specifically even referenced the 60-day expiration of the plea offer. From that point on, Judge, there was no response. There was nothing. The case was put on a contested docket, even though no motion had been filed. There was an oral request to put it on a contested docket. That's fine, that happened. And then when the contested docket was approaching in January, contested docket was first approaching in November. Ms. Heisel sent an email reminding counsel that he needed to file a written motion. Then in January, Ms. Heisel sent an email that says, I show this is set for contested hearing on January 28th. I don't have any motion. I don't know what it's about. Another email in January that says, no motion. Now we're past the deadline to be ready for the 28th. We'll have to reset the contested hearing. At that point in time, Judge, I was frustrated. I was frustrated with the fact that this case is backing up on our docket, and creating problems for us because we can't move a case if defense counsel's not going to do what defense counsel is supposed to do. So I told Ms. Heisel, withdraw the plea offer, even though it expired in October. Now we're in January. Withdraw the plea offer. I don't know what else to do. I can't get them to do their job. So Ms. Heisel sent an email withdrawing the plea offer. Counsel did respond to that. Responded by implying that Ms. Heisel was a racist and informing us that he would be filing an open record request asking for all cases where plea offers had been withdrawn, and the race of the defendant, implying that we were doing this on race, out of racial motivation. Highly offensive to me. Highly offensive to me, not to me personally, but that someone would say that about the Hillary Heisel line. So I responded with, there will be no more plea offers in this case. Mr. Weiner, shortly thereafter, I don't remember the exact time frame, came to me hat in hand. Interesting that it was him, not Mr. Head, but Mr. Weiner and I do have a closer relationship, have worked together more frequently, Mr. Head and I. Mr. Weiner came to me hat in hand. And I agreed that I would reconsider because he said that he was going to put together a mitigation package to present to us on why this defendant did not need to be convicted of felony. Because without a plea offer, their options were to go open to the court or to have a jury trial. And at jury trial, I believe we can win. And that would, even though it was a probation case, I was sure it still results in Mr. Hankins having a felony conviction for the rest of his life. So Mr. Weiner asked for the opportunity to present a mitigation packet. Would I reconsider? I said, sure. I still received that mitigation packet. So I don't know what happened to that. This morning, Trooper Rhodes came in to get ready for trial on Monday. And Trooper Rhodes said, why are we going to trial on this, man? This is a good guy. He doesn't need to be convicted of felony. And I wasn't in the office. I was at a meeting at the Sheriff's Department. And Ms. Heisel and Mr. Woodlight talked with Trooper Rhodes, sent me a text, asked me if I was going to be at the office today. I said, yeah, I'll be there as soon as the meeting's over. And when I walked in, they expressed their concern about the fact that they wanted to be certain that we were not punishing Mr. Hankins for the lack of action by his counsel. And that was not an easy conversation for us, not an easy evaluation, but basically in the end, it comes down to we have to be sure that we're punished. So that's when we decided that we would ask the court for a hearing today. And that if Mr. Hankins could in fact pass a drug test, that would be an indication that he's been living clean while on pretrial. and that perhaps he didn't even be convicted of a felony in this case. So I arranged for Mr. Waddell to be here on his day off, to drug test him. But then when I got over here a few minutes ago, I learned that for the first year and a half, for the first year, 11 months, I think exactly, Mr. Hankins didn't even report to pretrial as ordered. Once he did start reporting to pretrial, he has never actually gone to their office. They've always had to catch him here. He's never been drug tested. And when he was told he had to pay $10 a month to be supervised, he said, I don't have to pay that. And he's never paid a dime. So now I'm rethinking, well, maybe he does need to be convicted of a felony. But I don't want to do that. Because I'm not sure it's the right thing to do. And above all else, I need to do what is the right thing to do. So I think it would be the right thing for Mr. Hankins to pay that $10 a month that he owes since September of, I think it was 2020, when he first signed bond conditions. I think it would be the right thing to do for somebody who's responsible for us being here at the last minute to pay for the jury panel, summons that went out. But I can't force either of those, Judge. But I'm in a position where I believe, let me say it the other way, I'm not convinced that the right thing to do is to proceed to trial Monday and have Mr. Hankins be convicted of a felony for the rest of his life, is very much guilty, which is what we would ask him to do. So I leave the issue of the pretrial fee, the jury summons fee with the court. But if he passed the drug test, the state intends to dismiss this case.
All right, that's great. Mr. Waddell, can you address the statements made by Ms. Curry regarding whether Mr. Hankins has been drug tested or reported or not paid?
Mr. Hankins did test negative today, just moments ago, for all drug or alcohol substances. For the period of time that I've encountered Mr. Hankins, he has been good to report on the jury selection day as ordered, and that was when I would see him each month, or sometimes 2 and 3 times a month. But again, he's never paid the $10 supervision fee.
Did you address that with him?
Yes, sir.
Did you ever report to the court that he wasn't in compliance with pretrial conditions, or the reason if he wasn't in pretrial in compliance, that there's a reason for that?
Typically, I didn't. He was not on a docket where you would see him, and that could be my fault. He's a very likable, easy to get along with fellow, but I try to look at the big picture of dealing with defendants, and not to be just somebody out for money, but to try to monitor how they show up, what kind of condition, what kind of behavior they're demonstrating. And I confronted him, and that was his response to me. And I should have brought it up in a matter to have you put him on the docket because of that. And that's my error.
Has Mr. Hankins been drug tested throughout the period of his pretrial release?
No, sir.
So he's never been tested other than today?
Other than today, no, sir.
And just to be clear, Mr. Waddell, did he ever report to probation prior to getting put on the jury selection docket where he comes on Monday mornings and you come over here?
I never saw him at my office.
And what was his response when you confronted him about the $10 a month?
It was his understanding that he didn't have to pay that.
And how, do you know how he had that understanding or why he had that understanding?
He didn't want to talk about it. He just told me that he didn't have to pay them. If I, well, for me, that was his term, that he didn't have to pay that. And again, it falls back on me for not enforcing what you ordered him to do.
So before I give Mr. Head an opportunity to respond, so is there an offer from the state today? What I'm hearing is the state is offering to dismiss the case contingent upon a negative drug test to which Mr. Waddell says he's complied, and payment of pretrial supervision fee and jury summons fee.
Yes, sir.
Okay. So make sure I'm clear on that. Mr. Head, do you want to respond to that?
Your Honor, I think it's been pending about 3 years. I really didn't know the nature of the hearing, so I haven't gone back through and looked at all the emails or anything of that nature. If I offended Ms. Heisel or Ms. Curry, I apologize. And I would certainly ask that if I did something that offended someone, that not be held against my client. I appreciate their position in that regard. I think just from my brief conversation with Mr. Hankins, I think he was under the perception that he was not required to pay if he had retained counsel, that was for someone who had unretained or who had appointed counsel. I would just say, in my experience dealing with Mr. Hankins, he has always appeared at any point in time that he thought he needed to appear. I think I would guess he's appeared probably more than 20 times, that he's taken off days from work, and he does have a good job and a good career. And he takes off work on those Mondays to come down here to get his reset slip. I think if he would have understood that there was some additional requirement, that he certainly would have complied. I just, from my experience with him, he is not one. He's not the type of client that even calls me and says, "I've got something else going on that Monday. Can you get me out of court that Monday?" He's never once asked me for that. He has regularly been to court and taken care of it, and I've never had any indications where he's tried to get out of a drug test or out of a court appearance or out of any payment. So I think if there was a failure there, it was a misunderstanding on his part, and I'd ask for not to hold that against him.
And so, in as much as so we're at this juncture where we're set for trial on Monday, and the court has a policy, and the court's policy is the goal is to try to get the parties to come together and resolve if a resolution can be reached. If not, we set for trial, and the court does its job in making sure that the internal mechanisms are turning and jury pools are being summoned, and I'm using the taxpayer money to mail out summons and pay the jurors who show up. And right now, we're not even in our courtroom, so we're coordinating and we're going to different places, and we're paying those places so that we can ensure that everyone's right to a trial by jury is protected, and that our system of justice doesn't stop because of COVID or because that the roof fell in at the courthouse. With all of those things considered, it's frustrating to the court that I see that Mr. Hankins I've totaled him up. Today is the the 32nd time that he's made an appearance. 32 times. He was first arraigned in August of 2020. And I believe the last docket call in which I saw Mr. Hankins and I tried to determine, can there be a resolution in this case, was March 11th of 21. And I take that back. That was our first docket call. I allowed 3 docket calls. And then the last one, which is kind of where the court says, okay, are we going to get a resolution or are we not? And I think the offer at that time was 2 years, probated for 3, to which Mr. Hankins rejected. And we have gone down this path of setting for trial. And now we're there. We have trial set on Monday. The panel has been summoned. We've gone through that cost. We've set up trial at the City Hall in Canton. We're gonna pay a fee for that. And what I'm hearing the state say is that they're willing to dismiss the case, but we have some financial issues that I would like to have addressed if this is something that the defense wants to entertain. And if you need time to talk to Mr. Hankins about that, we can take a short recess. And what I'm trying to find out is, are we going to trial on Monday? Are we not? If we aren't going on Monday, then I would like to reimburse the taxpayers what it's cost to get us to this point. And I would like Mr. Hankins to comply with the court order that I placed him under. Even if Mr. Waddell says it's his fault for not bringing it forward, nonetheless, it's an order that he would not be in compliance with. So what if I could take the motion to dismiss under advisement? I could cancel the panel. We come back and revisit that at another time. I'm just trying to figure out, where do we go from here?
And Judge, to help with what we've got, I do have a copy of the pretrial conditions signed by Mr. Hankins, indicating that the $10 a month was checked, and that date was September 29th of 2020. That those were signed.
In your honor, I guess I could ask just so I could properly advise Mr. Hankins as far as the cost that I guess the state is seeking. I mean, I guess we're basically talking about $240 plus or minus on the probation or the bail supervision fee. I think that would be approximately right.
What date? What was that dated?
70.
9/29 of 20.
And so how many months is that?
28, 29 months.
Approximately 300, approximately, whatever
And
the $10 a month is.
does anyone know the other costs that are associated with it, just so I could tell him approximately, just so he can make an informed
I
decision?
think we summoned, and I can get the exact cost. I believe we summoned 400 jurors, or could be anywhere between 325 to 400. I can get that number. And that's just the cost of postage. It's just the cost of postage, so it's about half of that. And then I'm not entirely sure what the city of Canton is going to invoice us. I can call and find that out. I'm guessing that's going to be between 100 to 250.
Your Honor, I guess I would ask for either if say is going to file their motion, that the court take that under advisement as the court indicated and cancel the panel and let me speak with him, or that we have a recess and I speak with him if the state's. I guess I'm not real clear on if the state's saying they're going to file this motion to dismiss either way, but they would just ask that he agree to do that, or if they're going to file it and ask the court to impose it as part of the dismissal, or if it's a dismissal based on his payment of the cost. I'm not real sure I understand kind of what's being proposed, so I think I need to know what I'm telling him is accurate so he can make an informed decision.
Yeah, let's do this. Let's take a recess. Let me go upstairs and get the exact costs for you. And then when I bring those back down, then in the meantime, I'll let you and Miss Curry work that out, and then y'all can kind of tell me
Yes, sir.
what the position is, and then I'll bring those costs back that I know that we've incurred preparing for the jury selection on Monday for the trial.
Yes, sir.
So,
Want to make sure we're all the same page.
Prior to that, I would. Sir, do you have that copy of that contract that we looked at, or the pretrial conditions, or did you give that to me?
No, it's not here.
This has been a very long subject, and like I said, the 32 times I came, this was really right.
No, I understand. Well, you've been 32 days to work over it. I understand. Like, let's just look at this, just because,
And I explained that to them, and we had that conversation before I went back inside there. The lady came from the back, which means well, they went there, we just had parts for me. So it was another lady dealing with that and brought that back and brought that to the court's attention. Before I signed it, I would have never signed it. Because I wanted to be on the same page to understand it, but that's how it was explained. But those who do not have attention for those who have it, as they know, I have a chance, so there's no reason.
well, and I think, you know,
But let's explain to me, and yeah, I missed it. That's how it was doing.
what we have. Yeah. And I don't know why that is, Jack, and that's part of what they told you this, you know, Jack, and should. If the court determines you're abandoned, you what is green?
But at the same time, it's the same thing like you're doing to me, I can, I'm being told. That's all. That's just. Again, I was not going to see my frustration, but I do have frustration in dealing with, him, no, kind of trooper that comes to. Because she don't understand, I've already told you from the jump, you're taking into trial. So I get the process. And then there comes Justin, so the scared of her. Yes. I will obey it. Whatever it is, I'm just gonna leave it alone, because at the end of the day, I feel I don't feel, I'm gonna tell you my 100% belief, it is personal in more ways than one. But at the same time, just like that gentleman said, it's not abiding by that. Why have you not brought that before? And you wait till the last minute to bring it. If I'm not abiding by it, and I pray that you see that. If I wasn't abiding by it, I heard you say anything before. I reported before. He did ask me about it. He said, "It look better." Hey, I'm not paying something. He told me I'm not. And I would tell the judge that I wouldn't put him in no trouble. I go to no one else. I will stand for what I said. I told him that I'm not paying. If I need to be taking a year analysis, because I can take a year analysis, because it took one every time I came, every 32 times, 31 times. I have no problem with that. But at the end of the day, it's like you're hinging something that you have no case on something that makes no sense, that really kind of blows my mind again about, like I said, it wastes the taxpayer money. You've been wasting the money for a very long time on a case that presented in there, supposed to be marijuana, you did not find it. This blows my mind. And again, I'm trying to be very calm, and probably looking a lot of rates, but it's frustrating because this is the frustration I've had for almost 3 years dealing with something I didn't do. But now you pretty much tell me, well, you don't pay it, you go to trial, go to trial. I mean, that's what I want to say. That's what I mean. And I know that sounds bad, but that is where I'm at. You want to go to trial? Well, let's go to trial. Let's try our hand on something that I know in my heart of hearts, and you don't stand a chance to win. Let's be 100% honest. Since you're saying I'm wasting taxpayers' money. If you're that solid, I'm that solid. Because I didn't do nothing again. I pay you $240. But again, we paying for something that I shouldn't be on.
I understand how that. I think it's fun.
It's like, okay, now to come back. I'm very touched my emotions, but I'm serious, Mike, because I really am like, I've been. See, I live in this town. You're correct. People do know me. So I get the looks. I'm still thankful for a trooper who stand up and say something that you doesn't have to. For people, like I done everything right. I won't sit here and say that to you, to anyone. When it comes to this situation, no, I did not do anything wrong. And I've stood my ground for that for a very long time. I only really kind of have you slap me in the lawyer in the face about what's been going on. But if you felt that way about it, then why haven't you said anything in these 32 times I've been in this? And if you felt like that y'all wasn't doing y'all's job right, or y'all haven't complied, why have we not addressed this way before 32 times?
Have you never taken the presidents before? I'm sorry, that never asked.
Never asked. This ain't no compliant now. I would be compliant then. I have no problem with that. I don't have a problem taking a joke. I'm gonna pass it. So I'm not, well, that's why I was telling you, that's not a concern of mine. But what is a concern is, again, if we have wasted this much time and you were so irresponsible in being my counsel, and you were giving me such a bad representation of this job, why are we waiting to now to say something before we're getting ready to go to trial? And you're pretty much saying, well, I'm doing it ethically. What is ethical about that? Because there's no ethical, because if you care so much about what you thought I was or wasn't getting, why didn't you say something a long time ago? You have had nothing but time and opportunity. If you felt that I was being ill represented, basically what you're saying. So yeah, I do kind of feel some way about that, because you're kind of insulting me in a way, even though it's going through you.
No, I get you.
So, and I believe that you have done a great job. I believe in you. I believe in what you have done for me. So yeah, that's gonna kind of aggravate me. And period. Because again, you show me character about things and answer the question, and I don't feel like I'm getting from them. And again, it's a whole nother conversation. So if I gotta pay, I will pay. If I gotta pay for their jury summons and their stamps, I will pay. But trust me, I'm gonna get it all back. I don't know what happened. You can tell me what I need to do, but I will get it back. And like I told them before, and I hope you told them, I can tell them to their friend. Well, I can't tell them that, man. This is if I say, well, I'm trying to, I'm a terrorist threat, there's no threat. You get elected to this position, you forget, I am a taxpayer of this community as well, so. I've seen here for 2 years now. So, he is.
So hanging on.
That's from the judge.
You won't be the pay for the fact that y'all. That's what that's. I am personally this way, the right thing. I saw it, I'm being honest as I can, because you have insulted in more ways than one. I just have been so hell, I've been going there for 2 years, so. But don't sit in front of the judge and try to portray that you know so perfect in what you're doing. And it's like, I want to push you to the fact and show you that not being perfect, because if you're so perfect about what you're doing, again, common sense and get you busy, you get a chance to look at this. When you look at what you say you have or don't have, and notice you don't have anything. Yeah. And you feel that confident to a jury? Right. I'm not prideful by any means, right? I hope I can display that and I have no pride in me about life, but I do believe right. And that can be very assumed to be very prideful.
Well, in here, and number one, I appreciate it, and I appreciate the fact that since that point, you said I'm not pleading. I'm pleading guilty, and so these offers, and how they may done, whether or not they completely respond in an appropriate, fine line, and everything anything that are considering this is me negotiating, not you saying you did it. Is if they put a pretrial litigation on ground, there would be dismissal. And I would have brought that to okay.
Yeah, you spoke about that, about
Right. And even then, you said, I'm not gonna, sign these papers saying. But now we're at a different crossroads, and I appreciate it and understand all of the frustration. And it's real tempting to go back and say some things that aren't moving and like it's been so that's right. But it's saying that I'm not sure that's in your consideration. I mean, that's next year. You potentially some crazy juror decides instance. I hear them ready going to come. Whether they would do that, and said no. Swallowing the brains and often $700.
Yeah, as far as my problem, I'm not leaving about it, and I'm sorry, I'm doing it. You said, if I'm gonna die, you're gonna fall for everything, I die for what I believe, I'm sorry, I really will. Some people will say that. Like heartedly, not knowing the road or process and say that to be tried to see if you really believe that. Well, I do. I'm not gonna brother with it. I'm not a lot of people, a lot of things, man. I just write it wrong. I hope I express that in the most, I wouldn't say professional, but the most honest way that I can. And honest doesn't look good to some people sometimes. And right now, yes, I feel very, it ain't about how I feel. It just looks very, very sideways. You want me to pay $760, or we go. Pretty much. Still gonna try to stick me with 240 now, 240 in the game, anyway. Know that, right? Yeah, either way it goes, read 240. Because you're gonna say I've been under supervision, the way she alluded that I haven't been under supervision, but you look at when that was actually signed, not the time that I was arrested. That's day one. That you didn't even, you get what I'm saying? You didn't even think about that. It took about a year for them to actually get to the point to bring me in.
Here's what I would suggest. If they dismiss this thing, it still shows some grass.
Then I have to pay to get out, right?
If you don't have to pay it, get it charged. But if they do the dismissal in the inappropriate way, it could be something that we couldn't get responded. So I think we should say, we don't agree with this because it's not the way we understood it. However, in an effort to get this resolved. We are willing to pay the $760, but we want a dismissal and agreement that there will not be any opposition to us in this situation. We want to move forward and get this rational.
So what's the cause them to keep it from being exposed?
Certain language in the dismissal, if they said, you know, from the jury, I think we need to say, I'm not saying you would have been,
No, you're not, but it's my pride, you know, you wanna know my honest, or I believe you feel my pride, what my honest answer is, unless you started going. But I'm not gonna do it. No.
dismissal, where is yourself to the right. And so when it brings them to job. Him have a business fine. He's
Yeah, we don't have enough
I mean, I think there are certain ways that dismissal would have worded that said it was only dismissed due to some sort of suppression issue or something that would prejudice, you know, the people that can get it. We just want to make sure that he is going to be able to do it on his record.
Yeah, with this record on the actual motion. I'll probably just put it in the interest of justice. Yeah. There's nothing on it yet, so I'll just put it in the interest of justice.
All right, Mr. Hood, have you had an opportunity to talk with your client and the state, and do we have any kind of resolution?
I have, Your Honor. We had a lengthy discussion, and although to be quite honest, it's a difficult decision for him to pay this when, you know, he has been here 32 times and taken off 32 days of work. We feel like it is in his best interest not to face a potential trial, that if the cost of that is, you know, $760, then he would prefer to do that than face a trial on Monday. I have spoken with the district attorney's office. It's my understanding that the language of the dismissal will be such that he would be eligible for an expunction and that there would not be any opposition to any expunction, so that he can get this arrest off his record, because it has prejudiced him in his career and that sort of thing, to have that arrest out there. And so we would like to make sure that he's able to move forward with that immediately.
That's correct, Judge. The motion will file, will be on the basis of the interest of justice.
And so is there an agreement on expunction and agreed expunction and waiver of any statute of limitations that hasn't yet expired, or any waiting period? Is that what I'm hearing you say, Mr. Head? You said expunction immediately. Is that
Right, expunction immediately upon filing, Judge, yes.
okay?
All records except the DA's office records.
Okay. And so as far as satisfaction of the fees, is that something that Mr. Hankins can do today? Is it something that we're going to have to set a status hearing on and give him some time?
I think we would probably, I didn't specifically like that, but I think if we got 30 days, would that be sufficient?
I think it's important to that, fees for the information.
And I'm not sure that, I know that his office closes at noon, so he won't be able to.
So you want me to come in on Monday? I mean, I don't know if I need to go there on Monday.
Yeah, his staff will be there on Monday. That takes that. Mr. Waddell won't be able to do that.
In Your Honor, how are the other fees payable? Are those payable to the county? Or because I think the actual breakdown was $250 for the city of Canton fee, $210 for the postage, and $300 for the supervision fees, for a total of $760.
He's asking,
Why would it set on that for record for 24 months?
I was one that said that.
Well, I was explaining that, so I don't go to that. My supervision is set for 240 because and I will let the court know. I did tell them that I was under pressure on not to pay because I know when we refer to the motion to try and find some. They said we're going to the motion trying to actually find out about me getting my hunting license if I get to actually have a gun. And that was part of the things that you were thinking about. You said no, that you were going to sit with the hearing of my order. That I was set, that I asked, I came back out and asked, why am I paying this fee? And you explained that to me, that normally that's a fee that's paid for people who do not have counsel that should represent them. So that's why I didn't express myself and never say that I was not going to pay them. That was, I was under pressure, I didn't have to leave the lawyer's check. So that is what I said, but I'm understanding. What is it? Because I've just been past the 24 months, so as long as I'm under supervision, basically.
What should have occurred is when Mr. Waddell received the conditions of pretrial release and that box was checked for $10 pretrial supervision fee. What that does is that gets paid to the pretrial release department, which is within the Van Zandt County Community Supervision Corrections Department, and it pays for officers like him to take on this work of supervising. What should have happened is you should have began paying it immediately, and then as soon as you were about 3 months delinquent, he should have brought it to the court's attention at one of these multiple hearings that we had, throughout before you got on the jury selection docket, and I would have addressed it to you then. And I would have said, if this is not rectified, the next step will be a hearing on your bail in the case. And if it's a violation of pretrial release, you can have your bail revoked. That's what should have happened. That didn't happen. If there's if the pretrial release department wants to waive fees, then I have no problem with that. I don't know that Mr. Waddell can make that decision or not, but I know that that's what was assessed. And what I try to do is look out financially for the agencies, such as, well, it's the probation department, which I direct, and then also the taxpayers' money that we use to summon jury trials and those things.
And I think part of the confusion may have been also, Your Honor, it looks like on those fees, the $50 per month court appointed fee was checked, although he had retained counsel. And so I think maybe when he met with someone, that that's said,
understandable.
You don't have to pay this because you have retained counsel. And Mr. Hangus took that to mean he didn't have to pay anything because he had counsel, whether it's explained to him that way or however that got confused. That box shouldn't have been checked. And somebody told him, just disregard the payment. So
yeah, I believe that the court has modified its conditions since then for that very issue. And now it says, if you have retained counsel, or if you are indigent and receive court appointed counsel, you will pay this. And so it would, going forward, it relieves individuals who do not have court appointed counsel. So I know that has been an issue.
and that's what is said, Judge, if the court determines you're indigent.
There was check, and so apparently, so I don't know, but there was confusion.
I don't have a problem canceling the jury trial if this is going to be the resolution, setting this off 30 days to give Mr. Hankins time to do his end of the deal. Court has no qualms with that.
In Your Honor, Mr. Hankins has a very good payment record with me. He has taken care of our fees. I can assure the court, and I'll tell the court, if we need to get this resolved, as an officer of the court, I'll get a check in the mail for $760 on my back. Mr. Hankins can pay me back, so he doesn't have to take another day off work. Come back down here and miss more work and have more inconvenience. I'm sure he'll get the money back to me. I'm not worried about it.
Okay. That's acceptable to the court.
Do I make that payable to the community supervision department or to the county or?
Yes, I tell you what, make it payable to the community supervision pretrial release. What they'll do is they'll receipt the money and then they will direct it back to Van Zandt County. They have their separate line item accounts for supervision. And then that money will then go back to the treasurer's office, and then it'll make its way back to the clerk's fund where it comes out of for the postage and things of that nature. So that's probably the best place to do that.
Entire $760 to the community supervision part.
Yes. I think that's the best way to handle that. And then they can write checks over to the county for those specific items, and I can work with Ms. Burns on that.
Yes,
We have any other issues or questions about that? I think we're all on the same page.
yes, sir. We're just ready to get this over with.
So for the non-record that we don't have, the court's going to notify those that have been summoned for Monday that all the issue or all the cases set for trial will have been resolved, have them not report. And then the state's filing either today or Monday, the motion to dismiss in the interest of justice. And then at some point in the future, Mr. Hagan's going to be filing a motion or an application for expunction. And then either you, Mr. Head, or Mr. Hankins will be satisfying the financial costs pursuant to this agreement on Monday,
I will,
or at least put it in the mail on Monday.
I'll probably just put it in the mail. If
That's
I don't
fine.
have to appear on Monday, I'll just put it in the mail first thing Monday to the probation or community supervision department.
It's great.
Fine, Your Honor.
Well done. Okay, all right, then let's move forward with that, and guess we're resolved at this time.
Yes, sir.
All right, thank you.
Thank you.
Thank you. You're welcome. Thank you all for being here.